Bismillah ar-Rahman ar-Rahim. I'll be discussing the introductory section to the series of lectures on Usul al-Fiqh. Today is introduction to this subject. It is a mother discipline, a core subject in any university that offers courses on Islamic law and jurisprudence. To begin, we begin with the meaning of words. Usul al-Fiqh is composed of two words. Usul is the plural of asl. It means roots, origin, source, foundation. And fiqh is, of course, the name for the applied aspects of Sharia, Islamic law. Usul al-Fiqh here means the roots of fiqh. If we can visualize the Sharia into a tree, it has roots and branches. The Usul al-Fiqh are the roots of the Sharia, whereas the fiqh itself are the branches that grow in all directions. Usul al-Fiqh is the science of the sources of Sharia, and their order of priority in the methods by which legal rules are deduced from their proper sources. And the sources of Islamic law are divided into two types: revealed and non-revealed sources, naqli and aqli. The former provide the basic evidence of Sharia, whereas the latter provides the methodologies of extracting the rules of Sharia from the revealed sources. Fiqh as a subject, Usul al-Fiqh consists mainly of inference and deduction of the rules of Sharia from the Quran and Sunnah according to a body of rules that are collectively known as Usul al-Fiqh. Would it be accurate to call Usul al-Fiqh as methodology of law? Yes, it is correct, but it is incomplete. It would be better to say methodology in sources of the law, because the sources of law like the Quran and Sunnah provides little by way of methodology, and it is the rational proofs that provide formulas for the deduction and inference of rules from those sources. They provide the methodology. The methodologies that we are talking about consist, for example, of analogical reasoning, qiyas, heuristic preference, istihsan, presumption of continuity, istishab, and a number of other subsidiary proofs and formulas which each in their own capacity provide a different formula for ijtihad. The Quran and Sunnah as the revealed sources of Sharia are generally constant. They are not subject to abrogation and repeal, whereas the rational methodologies are changeable. But since the Quran and Sunnah discontinued at a certain point of time after the demise of the Prophet Muhammad sallallahu alaihi wasallam, we now have only ijtihad, interpretation and deduction as our principal tools in order to derive the rulings of new issues from the sources of Sharia, from the revealed sources of Sharia. What is the objective of studying Usul al-Fiqh, or the objectives of Usul al-Fiqh? Briefly, it is to encourage and regulate the exercise of ijtihad and to derive the rules of Islamic law from their sources through the methodology of ijtihad, whereas the Usul al-Fiqh as a science is concerned with the study of the sources and methodologies. The fiqh itself is the end product the rules that are obtained. They collectively are called as fiqh, or the positive aspect of Islamic law. The relationship between the two may be resembled with that of the language in relationship with the grammar. The language itself is the fiqh, whereas the grammar provides the governing rules for the proper application in use of the language. If we provide a definition for the fiqh, it is the knowledge of the practical rules of Sharia that are derived from their proper sources. Therefore, the person who attempts this exercise, the faqih or the jurist, must have knowledge of the sources and be familiar directly with the contents of the Quran and Sunnah. For example, to quote one verse from the Quran, "O believers, do not devour your properties wrongfully among yourselves." This is Surah 2, verse 188. "La ta'kulu amwalakum bainakum bil batil." This is the detailed evidence that exists in the sources on the prohibition of theft, for example. This is different from merely saying that theft is forbidden. That is a direct recourse to the detailed evidence in the sources with which the jurist must become familiar. Usul al-Fiqh also look into the rules of interpretation and the structure of sentences and words in their application, and how, for example, analogical rules, analogy or qiyas is constructed, what are the proper conditions that it must fulfill, what is the authority of the rules that are derived through analogy. And most of all, the mujtahid, the jurist, must know how to select the proper formula and apply it to an issue before him, whether it is istihsan or qiyas or maslaha. Which one of these would be most relevant in order to obtain the ruling of a new issue? Usul al-Fiqh also informs us of the limitation of personal opinion vis-a-vis the divine revelation. Now we ask a question whether it is accurate to say that Imam al-Shafi'i is the founder of Usul al-Fiqh. It is generally accurate, and it is recognized that the first work of authority that was written on the subject, the Risala of Imam al-Shafi'i, was the original contribution to this subject, and it is widely recognized that he is the master architect of this subject. But it would be also accurate to say that he was not the first that exercised the methods of reasoning we are mentioning. For example, Imam Abu Hanifa is known for his contribution of the methodology of qiyas, or analogical reasoning. Also, two other doctrines of Usul al-Fiqh, namely general custom and juristic preference. These are attributed to the Hanafi school. Imam Malik, who also preceded Imam al-Shafi'i, he is known to have contributed the doctrine of Ijma' Ahl al-Madina, or the consensus of the people of Medina, and Istislah, or consideration of public interest. When Imam al-Shafi'i came on the scene, there were already contributions, significant contributions made. But what he did, that he put them together, gave them an order of, placed them in a coherent order, and articulated the legal theory of Usul al-Fiqh as has remained with us to this day. After Imam Shafi, also contributions to the science of Usul al-Fiqh continued, and there were, of course, those contributions did not start even from these Imams of jurisprudence. Even before that, during the time of the companions, they have exercised ijtihad, and they have also shown us, given us the basic indicators of deducing, how to deduce the rules of Sharia from the sources, the Quran and Sunnah. And after the companion, to look at the history of Usul al-Fiqh, then the geographical domains of Islam widened, and the Sharia came into contact with other traditions, and there was a need now for a methodology to regulate the exercise of ijtihad. During the Prophet's lifetime, there was no need for methodology because he could deliver a ruling direct. And the companions also, they were busy, mainly engaged in the study of the Quran and authentic collection of the hadith, and it was not really Usul al-Fiqh that was in the forefront of their attention. By the time of al-Shafi, also much of the Sunnah, the hadith, had already been documented and provided the raw material for the development of the legal theory. One other factor that prompted Imam al-Shafi and others to articulate the legal theory of Usul al-Fiqh was the influence of the non-Arabs and the influx of non-Arabs into Arab society, and the anxiety that people with lesser qualification attempted ijtihad, those who were not even fully familiar with Arabic language. Imam al-Shafi wrote his book, the Risala, that discusses the Quran and the Sunnah, especially the solitary hadith, Khabar al-Wahid, the general, the specific, the subject of abrogation, general consensus, and so on. He refuted the Hanafi doctrine of juristic preference, and yet these were also, there is yet another claim, and that some of the Shia Imams, especially Imam Muhammad al-Baqir, the fifth Shia Imam, and Jafar al-Sadiq, the sixth Shia Imam, they made contributions to the subject of Usul al-Fiqh even before al-Shafi. But Muhammad Abu Zahra, the 20th century scholar, who has written books on most of these Imams, he has drawn the conclusion, yes, that the Shia Imams and others had made contributions even before al-Shafi, but no one else actually wrote a book, an authoritative exposition on the subject, as Imam al-Shafi did. So he is rightly recognized as the founder of Usul al-Fiqh. The four sources of Usul al-Fiqh, Quran, Sunnah, Ijma, and Qiyas, that were identified then in the Risala, have remained with us to this day. Then we discussed briefly this phenomena of the closing of the door of Ijtihad, Sadd Bab al-Ijtihad, around the 4th century, the Hijrah, 11th century, 12th century Common Era. Whether this also meant that the Usul al-Fiqh also came to standstill. The likely answer given to this is that the closing or the decline of ijtihad did not necessarily bring Usul al-Fiqh to a close. Most likely that the scholars of the era of taqleed that followed over the centuries used the doctrines of Usul al-Fiqh to support their own contributions and works. What is the difference, if any, between usul al-fiqh and qawaid fiqhiyya, qawaid kulliya fiqhiyya, legal maxims? When you mention these two expressions in Arabic, usul al-fiqh and qawaid kulliya, there is some resemblance of terms, whether they are different or the same. There is a difference. The usul al-fiqh is the science of the sources in methodology of the law, whereas qawaid and the legal maxims is a subject that belongs to the fiqh itself. There are brief extract on the subject, various subjects of fiqh, evidence, marriage, divorce, sale, etc., and they fall within the area of the branches and not of concern directly to usul al-fiqh. And then similarly we distinguish the usul al-fiqh from usul al-qanun. Usul al-qanun is the legal theory for parliamentary legislation. Usul al-fiqh is the theory of the Sharia. There are aspects in common, of course. Both of them are concerned with the sources of the law, the methodology of obtaining the legal rules from their sources, inference and interpretation. But the usul al-fiqh is concerned mainly with the Quran and Sunnah as the principal sources and the authority of reason vis-a-vis divine revelation, how to arrive at the rulings of halal and haram. There is a difference, of course, between this and the rational sources of legislation, parliamentary legislation. As rational sources, they can be changed, they can be replaced and repealed. Whereas the revealed sources of Sharia, they are not subject to the authority of any individual or group of individuals, either to abrogate them or to nullify them. So the usul al-qanun are rational sources, some of them historical, Roman law, common law. They are evolving all the times. And so does the usul al-fiqh, but there are some resemblances and some points that the two differ. A parliament can abrogate a particular legislation at any time without much difficulty. In usul al-fiqh also the ultimate authority, the sovereignty, ultimately belongs to the lawgiver, Allah subhanahu wa ta'ala, whose will is expressed in the Quran and Sunnah and established the basic structure of values, the right and wrong, the good and evil. And the sovereignty of people have a role in the legal theory of usul al-fiqh, recognized, for example, in the theory of general consensus or ijma', but it is the divine revelation that is the higher authority. And lastly, because usul al-fiqh also is concerned with the extraction of these 5 values: obligatory, forbidden, recommended, permissible, reprehensible, the scope of the study of Sharia is wider than that of the secular legislation. And there are 2 approaches that I will briefly identify that the ulama of usul al-fiqh have taken to the articulation of this discipline. One is the theoretical approach and the other is the more practical approach. The theoretical approach is that of the Shafi and the mutakallimun, the theologists. They were mainly concerned with articulating the doctrines and theoretical guidelines of usul al-fiqh and did not concern themselves very much with the application to particular issues and areas. Sometimes they engage in highly theoretical discussions. What was the authority of a ruling of the Prophet before he became Prophet. In those discussions that are of little practical importance. Whereas the second method is the Hanafi method, in the method of the Fuqaha, so to speak. They are deductive, and they also concern themselves with the applications of those theoretical doctrines. When there is a situation that the theory needs to be looked into in order to address a particular issue or subject, they make concessions and sometimes change the theory so as to meet the requirements of practical developments. Then after, when you look at the history of Usul al-Fiqh, there came a time in the 7th and 8th century, a number of authors combined the two, theoretical and practical approach to the articulation of Usul al-Fiqh. And I have in my book, Principles of Islamic Jurisprudence, given the titles and names of many authors who contributed through the application of this combined approach. My next subject is the Adilla Shar'iyya. This is what the Usul al-Fiqh is concerned with. Adilla is the plural of dalil, evidence, guide, proof. If one were to summarize Usul al-Fiqh into two words, this would be the Adilla and the Ahkam, the proofs and the sources and the rules that are obtained from them. And between these two, it is the proofs that are the more important, because the rules are obtained from the sources, and the ahkam that we have are the end product that are extracted from the source guidelines. The adilla are classified in different ways. One is the adilla transmitted proof, rational proof. Adilla naqliya, adilla aqliya. The naqliya are the Quran and Sunnah, and also shara'i man qablina, revealed laws that came to us prior to the Sharia of Islam, that Islam has also recognized. Then the transmitted proof, all the other proofs that are discussed in Usul al-Fiqh because belong to this category. Analogical reasoning, qiyas, belong to the rational proof category. Why? Because there is a pillar of analogy, effective cause, al-illa, which is a rational exercise, and because of that it is classified under rational proofs. It is believed that the Quran provides the indications to the identification of the sources. In Surah 4, verse 59, when you read the verse in detail, as I have discussed in my book, it provides the authority that the Quran and then the Sunnah of the Prophet, and then after that the decision of those in charge of the affairs, in other words the consensus, and then analogy. These are indicated into the ruling of that particular verse of the Quran. Then there is a distinction we have drawn between dalil and amara. Dalil is evidence which can engender decisive rules, whereas amara or indication or sign is known to be one that can only deliver speculative rules. The next classification of adilla shar'iyya is into independent and dependent proofs. Independent proofs are three: the Quran, Sunnah, and general consensus or ijma. Despite the fact that ijma depends on a basis or sanad in the higher sources, but once it is concluded, it stands on its own feet and it is an independent source. All the other sources belong to the second category of dependent sources. And then the next classification, the final classification of the proofs of Sharia or Adilla Shari'ah, is to definitive and speculative, decisive, qat'iyya and zwanniya. Into the first category, decisive, three sources: Quran, Sunnah, and general consensus. They are sources that can deliver binding rules. Although none of them are all, they do contain rules which are less than binding. But on the whole, these three belong to the qat'iyya category, whereas all the rest they fall under speculative sources. An evidence may be decisive from the perspective both of authenticity and meaning, riwayah and dalala. And most of the Quran is all authentic, but there are parts of the Quran that are open to interpretation and they are not decisive, whereas the ahad hadith, solitary report, they are speculative in respect of authenticity, although they may have text as they do that deliver decisive meaning. And finally, the classification of adilla shar'iyya, we have into two categories of those which are generally agreed upon, muttafiq alayha, and those which are disagreed, mukhtalaf fiha. The Quran and Sunnah are the primary sources of Sharia by common acknowledgement. No one has disputed this. And the vast majority of scholars and mazahib recognize also analogy in ijma, consensus in analogy as accepted sources of Sharia. Although the Mu'tazila, a group of Mu'tazila and some Khawarij disputed the validity of ijma, and similarly the Zawahiri school and the Shia, they do not recognize the validity of qiyas as an authoritative source. All the other proofs of Sharia apart from these four fall in the category of disagreed upon sources. When we talk, for example, of maslaha or sadd al-zara'i or istishab, as we will be discussing each of these separately. Sometimes the speculative or the doubtful ruling of Quran and Sunnah can be elevated into definitive by means of ijma. When general consensus throws its support behind a particular interpretation, it raises it from speculative to the definitive. And the difference also is that a ruling that is decisive and qat'i needs little to no interpretation, and it stands on its own feet. This was the discussion of adilla shar'iyya in their classification.